with 44. Today I am having some personal difficulty. Can it be matter taken out next week or after 2 weeks, Your Lordship?
44 is an order matter. Why are you mentioning an order matter? Let it come.
I have some personal difficulty today.
As prayed for by Mr.
H. Borwal.
H. Borwal, Learned Counsel for the petitioner, with consent from the other side. List this matter again on?
After a week, Your Lordship.
After 2 weeks, on a date to be fixed by the registry. Next.
May I please? With the consent of other party, I beg to mention item number 22.
22? Yes.
Well, this matter may be taken up after 2 weeks, my lord.
You are Mr.?
A.K. Datta.
As prayed for by Mr. A.K. Datta, Learned Counsel for the petitioner, with consent of the other side, list this matter after 2 weeks on a date to be fixed by the registry.
Interim order is there.
Interim order, if any, shall continue till then. Next.
Please, Your Lordship. I beg to mention item number 35 and 36.
35 and 36?
Yes, Your Lordship.
CD not received, my lord.
35, 36. As prayed for by MS
K. Bhattacharya.
K. Bhattacharya, Learned Counsel for the petitioner, list this matters
On 9th of April, my lord.
on 9/4,
Yes.
2024. Stop.
Interim to continue.
Interim, if any, shall continue till then. Next.
May it please your lordship, on a back to mention item number 39, my lord.
Yes.
But I've been informed there is no case diary, my lord.
Mr. Parashar,
Yes, my lord. CD not received.
as prayed for by Mr. S.M. Abdullah P. Learned Counsel for the petitioner, list this matter on
Sirang, my lord. 9th of April.
9/4/2024. Awaits CD. Next.
When the interim may continue.
Interim, if any, shall continue till then.
I'm obliged, my lord.
Marshal, in both 35, 36, 39, on top, await CD.
May I please, Your Lordship?
Yes.
I beg to mention item number 43, Lordship.
43,
I believe the
CD,
case
Is there
was
not received, my lord?
But we are not on interim, Lordship. Kindly the matter may be fixed on 28, Lordship.
as prayed for by Mr.
V.H. Chaudhary, Lordship.
P.A. Chaudhary,
Lordship V.
B.
Lordship,
V.A. Chaudhary, Learned Counsel for the petitioner, list this matter on
28 from Kamrup, Lordship.
20,
28 of March.
20, 2/8/3/2024. Stop. On top, await CD.
Highly obliged.
Withdrawal.
Yes.
You've been the petitioner has been arrested in the meantime.
Yes.
Why do you want to withdraw the AB?
Yes, AB.
Why want to?
Mr.
As far as the party's interested.
Mr. Your name?
Islam.
Mr. A. Islam, Learned Counsel for the petitioner, submits that the petitioner that he has received instructions from the petitioner that the petitioner does not wish to press the anticipatory bail application. Stop. Prayer allowed. Petition stands disposed of on withdrawal. Yes, Mr. Prasad. 302. 302.
302, 376.
Call CD. List on.
Scan copy of it. Charge sheet has already been filed. Trial is going on.
Let the scan copy of the LCR be called from the court of.
Additional session judge.
Counsel, you don't have the name of the court. You are
Additional
seeking the
session
bail.
judge number 4. Additional session judge
Additional session judge.
number 4.
Number 4.
FTC, Kamrup Metro.
FTC. Kamrup Metro. Through the registry. List on.
On my lord, 24th of April.
List on.
24/4.
24/4/24.
Right, please, Your Lordship. Lordship, this is a 439 bail application. May I pray, Lordship, let this matter be come up with AB number 787 of 24, Lordship.
As prayed for by Mr. B. Chaudhary, Learned Counsel for the petitioner, list this bail application along with
BA number
787 number
787 oblique
787 stroke
24.
2024
Fixed on 8/4.
on 8/4/2024.
Highly obliged.
Yes, Mr.
May I please, Your Lordship? Lordship, kindly
Call for
Taken up
CD.
sometime.
List on Mr. Borthakur.
List on, my lord, 4-4, my lord.
4-4-24.
Lordship, 79 days behind the bar.
Next.
Kindly maybe short.
79, then my lord, 1-4, my lord.
1-4.
May I please, your lordship? This is 439 application, my lord.
307-326.
Yes, my lord. CD is required, my lord.
Call for CD. List on
On 4-4, my lord.
4-4-24.
My lord. Obliged.
376. Call for CD. List on
On, my lord, 5-4, my lord.
5-4.
Lordship, case diary along with medical reports.
Call for CD along with medical report. 5-4-24. 366.
Yeah, your lordship only kindly see page 11.
Page 11, Mr. Ahmed.
I was arrested on 3-3. At a zero inquiry. Actual culprit is one Ghulam Nabi Azad. They have the law waivers with that.
Alright, let the CD come.
Yes.
Call for CD. List on
On, my lord, 2-4, my lord.
2-4. 307, Mr. Abdullah.
8 page, your lordship. There, my lord. 325 is there, my lord. 325 lordship knows it's available, my lord. It's a fight regarding, my lord, punching of a-
307 is also there.
Yes, but my lordship, see, my lord, it is a clash between two sister-in-laws, my lord.
Bail, Mr. Borthakur, CD.
On 1-4, my lord.
Call for CD 1424.
Can it be 28, my lord? 28. But because they are sister-in-laws, my lord. Because it's
Alright, 28-3.
obliged, my lord.
Call for CD. List on
On, my lord, 9-4, my lord.
9424.
Supplementary list for motion item 14.
Yeah, please. You know, this is 439 application.
Offense is under
Petitioner was arrested on execution of warrant of arrest. They were arrested on 27/2/2023.
399.
My lord, since 29/6/2018, the petition.
CD, call for CD. List on.
My lord, charge-sheeted case. sir.
Charge-sheeted case,
Scan
sir.
copy of LCR.
Let the scan copy of the LCR be called from the court of
My lord, may I pay one thing?
from the court of
From the Court of Additional Session Judge
additional
number
session judge
Number one.
number 1
Kamrup Metro.
Kamrup Metro through the registry. List on.
On 25-4, my lord.
My lord,
You want a shorter date?
my lord,
Then, my lord, on 10-4, my lord.
10/4/2024.
sir, in that case, my lord,
Next,
in that case, my lord, I may be allowed to withdraw, my lord.
you'll withdraw.
Withdraw.
All right. In item 48,
My lord.
heard Mr. A. Ali, learned counsel for the petitioner. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. Mr. A. Ali, learned counsel for the petitioner, submits that he has instructions from his client not to press the bail application. Stop. In view of the aforesaid endorsement made by the counsel for the petitioner, the bail application stands disposed of on withdrawal.
Obliged.
Daily list for motion item 9.
Pass over for time being, Lordship.
Item 9. All right.
Item 10.
Time being.
May it pleases your Lordship.
Yes.
My senior chief hotel is on leg in another person kindly pass over the matter for time being.
Please speak in front of the microphone.
Pass over the matter for the time.
All right.
Item 11.
Yes, Mr. Nawaz.
Lordship, this is a joint application for quashing of an FIR on compromise. My lord, to find the FIR at page 15. Basically, my lord, a dispute between a boyfriend and a girlfriend. Boyfriend lodges the FIR, alleging that his girlfriend has been accessing his Facebook and Google accounts, my lord. And read the FIR, my lord, at page 14, my lord.
Has the statement of the girl been recorded?
My lord, the FIR was lost. Thereafter, my lord, nothing has happened for the last 2 days. Now we have compromised. That boy has.
No, let the statement of the girl be recorded, and then this court shall consider.
Otherwise, my lord, we have election. This petition has been filed by the girl herself, my lord.
That's
Joint
all right,
application,
but this court desires that her statement be recorded by the concerned.
Then an observation direction may be given because otherwise the court will not.
Right, Mr. Parash, Mr. Das. In item 11. Heard Mr. S. Nawaz, learned counsel for the petitioner, stop. Also heard Mr. D. Das, learned APP for the state respondent, stop. It is submitted that this criminal petition has been filed jointly by the victim and the accused for quashing the subject.
I'm extremely sorry, my lord. The girl is not the victim here, my lord. The girl is the accused, my lord. The boy is the victim, my lord.
The accused. What is?
Can you see the FIR?
Where is the FIR?
FIR, my lord, page 14, my lord.
Page?
These are compoundable offences, my lord.
Page?
14, my lord. I'll read the FIR, my lord.
Yes, please.
With due honor, I beg to state that Miss such and such, resident of such and such, tracked my mobile and hacked my Facebook and Google accounts. She apologized for that with written, but I am still fearing about this matter because as she can manage or collect Facebook and Google passwords in future, she will again dare to access into my Facebook and Google accounts. After knowing her crime, I blocked her phone number, but she calls me from another number. I am surprised that she has more than 100 numbers, but how can it be possible? Few days ago, she gave me a major threat to burn my body throwing kerosene. Few days ago, she opened a fake account using my name to damage my image. She gave me threat that she will destroy all software of my phone. She still sends messages.
Who has filed this petition? Both of them?
The boyfriend, my lord. It's registered under compoundable sections, my lord.
Ashok Kumar Nath is the complainant,
Complainant, my lord.
and Bijoy Lakshmi Bora is
Is the accused, my
is the accused.
Boyfriend and girlfriend now.
Now, is there any affidavit
Well,
of
we have given-
compromise?
Yes, my lord.
Where?
At page 18, my lord. Page 18, my lord.
Page
18, my lord.
18.
18, my lord.
And this FIR is registered under
66C, 66D, and 67 of the ITF.
66?
C,
Yes.
66D,
Yes.
and 67 of the
And
ITF.
67
my lord.
of the
IT Act,
IT
Information Technology Act, my lord. All are compoundable, but since trial has not commenced, we could not compound.
IT Act খন এবাৰ লাগিব মাৰ্কলি IT Act. Where is the affidavit?
Page 18, my lord.
No, that I have seen. Page of the accompanying affidavit.
Oh, I'm sorry, my lord.
Affidavit is filed by the complainant.
By the complainant, my lord. Complainant, page 9, my lord.
These are compoundable.
Compoundable, my lord. My lord will kindly see section 77A.
77?
A.
Yes.
My lord, a court of competent jurisdiction may compound offences other than offences for which the punishment for life or punishment for a term exceeding 3 years has been provided under this Act. All of these, my lord, maximum punishment is 3 years.
Maximum punishment is
3 years, my lord.
3 years.
66.
66C.
66C, my lord. Punishment 3 years, my lord. Punishment for identity theft.
One sec. Punishment of theft 3 years. Yes. And then
66D
66D.
is punishment for cheating by personation. Again, my lord, punishment which may extend to 3 years.
3 years. Then
My lord, section
60.
67. 67, punishment for publishing or transmitting obscene material which is anywhere not affected in this case, my lord. That is also, my lord, 3 years and with fine up to 5 lakh rupees. Only in second conviction, my lord, then 5 years, my lord.
So 67 is also 3 years.
3 years, my lord.
All right. Dispose it of. We cancel the first order. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 482 of the CRPC 1973, filed jointly by the complainant I. Ashok Kumar Nath and the accused Bijoy Lakshmi Bora, I. Bijoy Lakshmi Bora, for quashing of the FIR and consequential proceedings in connection with Nunmati PS case number 409/2021, registered under section 66 capital C, 66 capital D, 67 of the Information Technology Act 2000, on the ground of compromise between the parties. Stop. The facts of the case is that the petitioner number 1 and petitioner number 2 had a history together, and following several months into the relationship, disagreements and turmoil arose between them, for which on 13/7/2021, the petitioner number 1 filed an FIR alleging inter alia that the petitioner number 2 has hacked the Facebook account of petitioner number 1, correct?
Yes, madam.
And is threatening thereof. Stop. It is stated on oath at paragraph 5 of the petition that the FIR was lodged in the heat of the moment due to a dispute between them, and after lodging of the said FIR, the petitioner number 1 and the petitioner number 2 has settled their disputes amicably. Stop. The accompanying affidavit is sworn by the complainant stroke petitioner number 1 on behalf of petitioner number 2 stroke accused as well. Stop. Further, it appears that a deed of compromise is enclosed as Annexure 2 to the petition, which shows that the matter has been settled amicably between the parties. Stop. Section 66C, Section 66C, 66D, and Section 67 of the IT Act provides punishment which is less than,
May extend to 3 years. May extend to 3 years.
which may extend to 3 years. Stop. It would be pertinent to refer to Section 77A of the IT Act, which reads as hereunder. 77A, you extract, okay? It appears that since the offences are compoundable and the matter has been amicably settled between the parties for the ends of justice, further proceedings in connection with the FIR, subject FIR, is not justified. Stop. Accordingly, further proceedings in connection with FIR number
Nunmati PS case number 409/21.
FIR, further proceeding in connection with FIR in FIR within bracket Nunmati PS case number 409/2021 stands quashed. Petition, with the aforesaid observation, this petition stands disposed of.
I'm deeply obliged, my lord.
I may be excused, Lordship. My Lord,
In item number 8, Lordship, I was about to reach Lordship.
You wait for your
My Lord,
turn, she will call. It has been passed
Lordship,
over for
matter
time.
on-
It has already been passed.
Where?
Called and
My Lord, after this statutory period, Lordship, 90 days. So,
I'm sorry, I cannot get what you are saying. We can give you a shorter date. You want a shorter
my
date?
Lord, I could not know, my Lord, case diary was called for in another case, Lordship, that is available in the office, Lordship. My Lord, already that.
All right, then
was-
we'll have it on
My Lord,
28th.
my Lord, and submitted.
28.
It may be taken up at 2, Lordship.
28.
It may be at 2 taken up.
28.
My Lord,
Next.
Immediately after, on the, my Lord, opening.
I have fixed it on 28, Mr. Counsel. After
Lordship.
opening.
Lordship,
Yes.
oblige, Lordship.
item 12.
Lordship, here the NBW is issued against the petitioner, my lord.
Kindly speak in front of the microphone. Because you see, there is a partition, glass partition. It's difficult to hear if you don't speak in front of the microphone. Yes.
Lordship, at page 15, my lord, the NBW is issued against the petitioner, my lord. On that day, my lord, a petition has been filed, my lord, that was rejected and NBW is issued, my lord. This is very-
NBWA. This is against NPWA.
Yes, my lord. On 3 days, my lord.
Why the accused was absent?
My lord, page 15, my lord. He was suffering from illness, my lord. Petition was filed, my lord, but that was rejected, my
Mr.
lord.
Das?
My lord,
All along he was on bail, my lord.
one thing I would not understand, my lord. Here, my lord, charge sheet was submitted in 2015. For all these years,
SDGM
what is this? Huh?
committed here also. It was filed before the SDGM, my lord, and it was committed in the year 2022 only, my lord.
After that, were you appearing?
Yes, my lord. At page 14, my lord. Kindly have. At page 14, my lord.
Yes. 17/8/22, Mr. Das?
Here, my lord, 14 cases, they were on bail.
Bail, my lord. So, my lord, I am ready to appear on 2/4, my lord. Next day this speaks on. At page 17, my lord.
What happened between 18/8/2022 to 22/11/23? Were you appearing or you were not appearing?
Sometime appear and sometime not appear. my
You,
lord.
those facts has to be before this court. You see, you come up with a petition for revision doesn't mean mechanically and in a routine manner this court is going to say that you go and appear before the trial court. There has to be a case. What happened between this period? Because you are on bail, that means you must appear regularly before the trial court, correct? If you fail once or twice, that this court may consider. But what happened from August 22?
My lord,
Now we are in 24. That period, no explanation.
my lord, on 22/11, my lord, petition was filed. That was rejected, and thereafter.
You file an additional affidavit and bring everything in record.
Ordership, no, ordership.
Get that.
My lord, the next 2 dates, my lord, the council was.
You bring it on record. What happened in between that period? List on. When can you bring it?
It will, again, I have to obtain the certified copy, my lord.
You are seeking for a relief. You should know what are the documents that you need to annex. What are the explanation that you must plead.
On 28, my lord.
List on 28 so and so, and to enable the petitioner to file an additional affidavit to explain as regards the period between 18/8/2022 to 22/11/23 as regards the status of appearance of the petitioner before the trial court. Yes. Yes, Mr. Fukan?
Quashing petition.
Yes.
I just stated facts, Your Lordship. What I'm
Quashing
asking
of what?
It's a
Proceedings?
yes, it's a
Complaint case?
Yes, it's a defamation suit which has been filed. Now, there is a company called Novex. Novex has certain music rights which are in form of a royalty that they enjoy. The allegation is that, by the petitioners who are before you, is that this music can only be used by paying a royalty. Now, there are certain FIRs which have been filed by the petitioners here who are residents of Pune.
Residents of?
Pune. The publication that has come, it speaks about an FIRs that have been filed against Novex, who apparently in garb of this copyright and this license fee and royalty fee have been extracting money from various hoteliers and music functions where this music is played. Now, if there is a violation for the music and the licensee right, then there is a Copyright Act. Somebody has a right to go and use that forum if it is available. Now, certain FIRs were filed by us, that is the Hotel Association. Now, these are certain members of the in Pune FIRs. Now, those FIRs are pending investigation, charges has not been filed. Subsequently, on 17/11/21, an article was published by a trade magazine in Pune stating about these FIRs. Now, these are facts. There's no allegation. The only allegation made is that these company, which is Novex and PPL, have apparently been extracting money. Now, that's the only allegation. Now, in terms of
Petitioner is Novex.
No, petitioners are certain people who are part of our hoteliers association because it is in their hotels this music was played. So apparently these people have been going to these hotels and extracting money. Explanation to that is by a notification of the government which says there are certain areas in functions like marriage halls and religious functions this music could be played, and there is an exemption given by the government of India. Now that part is a separate proceedings altogether if there is a violation for it. Now in 2022 a complaint is filed here stating that one of the employees of this Novex company goes to a hotel and apparently he's been cited about this article where they have been extracting money and he's been alleged to have been done fraud. This guy is apparently a business head of this organization, but he says I filed the complaint of defamation in terms of an individual person. Now the people who should be actually been aggrieved is Novex because the allegation is against Novex. It's not an employee of a company. He does not say what is defamation against him because there is not a single allegation in the publication against Mr. Khojandas who files the complaint here, the CR case. So my question is that when there is no allegation against you, defamation, your lordships understand the mandate of law is that it has to be an aggrieved person. Now who's the aggrieved person? The aggrieved person is the company who's
So the complaint that you're seeking of quashing is a defamation complaint?
Yes.
Which is filed by the employee of Novex.
Yes, but he says in this complaint that he is filing in an individual capacity.
And the statements,
yes,
which according to him is of defamation quality,
yes,
is made by whom?
Is a contents of an FIR.
Which is filed by
made in Pune,
which is filed by the association.
By the association.
Against
people.
whom? Against Novex. Novex. But Novex
company
is not before the.
Not before the court.
Let's see the complaint.
Let's
see the complaint.
Yes, your lordships. Page 29 is the complaint, and I would like to take your attention to page 33 first.
Khojandas.
Yes, Khojandas. Khojandas.
Correct.
Page 33. The first paragraph, the complainant is working with the company Novex Communications so-and-so as a business development executive. Page 33. Your lordship has page 33.
Yes.
And is hence conversant with the facts in present case and as such able to depose the same. Next paragraph is extremely important. I am filing this complaint in an individual capacity for the harassment and mental agony caused by defamation purported by the accused.
Where are the contents?
Yes, it's at page 52. May I just before that take your lordships to the FIRs that have been filed?
Page 52, let's go to 52 once.
Page 52. At the bottom, defamatory content. On 17/11, that's the newspaper that's the publication in the magazine. It's on the bottom. It is extracted, reproduced. May I just read your lordships?
Yes.
Pune Hoteliers Association met with Pune Commissioner Amitabh Gupta. Now these are the people who are the petitioners before you are part of the association.
You are representing the Pune Hoteliers?
Yes, association. They are members of the association. Yes. Next page 53. The representative of Pune Hoteliers Association has felicitated the Pune Police Commissioner Amitabh Gupta for taking prompt and effective action against the coercive action of the copyright agencies PPL and Novex. Now that's a Novex company. Illegally extortion in the name of copyright license for playing music, DJ music in wedding and related social events. Already 3 FIRs have been filed. Now these FIRs have been filed by us. For the same reason, the association urged guest and hotel management to come forward and file FIR in the nearest police station if exploited for wedding and related functions in these copyright agencies of Novex and PPL. Again, Novex and PPL. The association thanked Mr. Gupta and Pune Police for taking such bold and strong move would hopefully put an end to this illegal extortion or to the rest forever. A memorandum on behalf of PHA has also been submitted to Mr. Gupta, so-and-so, and so-and-so.
Nowhere the name of the present petitioner appears in this article.
Nowhere. So the defamation for the fact that there is an ingredient of aggrieved person is not even available.
Where do we get that definition?
Yes, that I have quoted in my petition also, Your Lordship.
Page?
Yes.
And then
page
show me
12. I have made the assertion. Para 9.
Para 9?
Yes, page at the bottom, 4 lines at the bottom. It is also pertinent to note that the learned chief minister lost sight of the bar under 199(407), which mandate that the petition of complaint of a criminal deficiency can only be maintained at the behest of an aggrieved person.
Page 9.
Page 13, para 9.
Yes.
Lost sight, which mandates that the petition of a
Page 13, para?
page. This is page 12.
Part
para
of para 9.
Yes, part of para 9.
All right,
Three
all
lines
right,
on the
all right.
bottom.
Read,
And on
I've
the
got
top,
it.
the criminal defamation can only be maintained at the behest of an aggrieved person. That is, the person who has been alleged defamed. The complaint himself admits in para 2 of his petition that the complainant has filed a complaint in his individual capacity and not in a representative capacity of Novex. However, in none of the news articles, the name of the complainant appears, nor any reference has been made to the complaint.
All
Hence
right.
the complaint. And after the investigation...
All right,
has been
Mr.
done-
Fukan.
Yes.
Only till the returnable date we shall stay.
This complaint itself is lodged in the counterblast because the three...
Heard
FIRs
Mr. R.B. Fukan, learned counsel for the petitioner, stopped. Who are the state of Assam is there? Also heard Mr. D. Das, learned APP for the state respondent, stop. This is an application under section 482 of CRPC for quashing of proceedings in CR case number 4788 of 2022, pending before the learned judicial magistrate first class Kamrup within bracket M at Guwahati. Stop. The facts of the case is that the petitioner has filed, sorry, not the petitioner. Facts of the case is that the respondent number 2
Yes.
has filed a complaint case being CR case number 4788 of 2022 alleging before the learned CJM Magistrate Kamrup Metro at Guwahati, alleging inter alia that defamation has been caused to him by newspaper articles which has been published on 17th November 2021 in, within bracket, Today's Traveller, with a title within quote, Pune Hotelers Association, comma, HRAWI and FHRAI take effective action. This is within double quotes. In the city of Pune, as well as available on URL. You see, Mashra, you will get it in paragraph 3. I have marked it here at page 5. Available on URL dash and on 5th October 2021 in, within double quote, Pune Mirror in Pune with a title within quote, Police will let the music play, and that the said article is available on URL dash. You will get the contents here. Stop. It is the further case of the respondent number 2 that another article was published on 1st October 2021 in Punekar News with the title within bracket Pune extortion cheating case registered against music companies agents for demanding license fee for playing songs in ceremonies, close quotes, and the said article was also available on URL http dash. You will get these at page 6. Okay. Extortion cheating case registered against music companies agents for demanding license fee for playing songs in ceremonies. Stop. Mr. R.B. Fukan, learned counsel for the petitioner, submits that the complaint that the complainant cannot be said to be an aggrieved person, as assuming the contents of the articles are correct, the defamatory contents are against a company of which the petitioner, of which the respondent number 2 is an employee. Stop. He further draws the attention of this court to paragraph. Where is that paragraph? Individual capacity?
Page 33, para 2 of the complaint.
To paragraph 2 of the said complaint, where the complainant states that he has filed this complaint in an individual capacity for the harassment and the mental agony caused by the defamation purported by the accused. Stop. He further submits that Section 199 of the CRPC mandates that a petition of complaint for criminal defamation can only be maintained at the behest of the person aggrieved, i.e., the person who has been allegedly defamed. Stop. Issue notice returnable 2 weeks. Mr. D. Das accepts notice on behalf of the state respondent, extra copies within the course of the day. Registered post AD in case of respondent number 2 within a period of 2 days from today. Stop. It appears that the complaint has been filed by the respondent number 2 in his individual capacity and not in the representative capacity of the company against which there appears to be, against which allegedly defamatory statements have been made in the article, in the subject article. Stop. That being so, further proceedings in connection with
CR case number
further proceedings in CR case number 4788 of 2022 pending before the learned judicial magistrate Kamrup Metro at Guwahati shall remain state till the next date. Stop. List accordingly.
Grateful.
Item 14.
May I please Lordship? So there are 4 application Lordships. FIR is a page 10 Lordships.
307.
Lordship, but a controversial FIR Lordships. Earlier we have filed, thereafter they have filed. Well, a conflict between brothers Lordships for some money Lordships. And the petition 1 and 2 also admitted in the hospital Lordships. And after 2 days they released Lordship from the hospital. We file our affidavit FIR on 10 3 Lordships and they file on 11 3 Lordships.
Allegations are serious. Mr. Das.
My lord.
Iron rod.
Cross case is there, of course, but my lord,
Cross case is there.
Cross case is there.
Then let him appear.
But condition, my lord, is the victim of this case, in which he is my lord, seeking anticipatory bail, was referred to GMC. So we do not know what is the condition.
We'll have it on
and
28.
The vital part of the
28 CD.
Lordship, we have, my lord,
28. Call for CD list on 28, Mr. Counsel, 28/3/2024. Yes, next.
Item 15.
May I please your Lordship?
376(1).
Yes, Lordship. And case 9 Lordship FIR. In this case, Lordship, whenever love appears, both the parties, the informant and accused Lordship. Case 9 Lordship FIR.
Love affair.
Yes, Lordship. They clearly stated in the FIR, Lordship.
Let him appear, Mr. Das.
Yes, Lordship.
There appears that there was a history between them.
Yes.
Yeah, Mr. M.A. Mondal.
M.A. Mondal.
Heard Mr. M.A. Mondal, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC 1973 seeking pre-arrest bail to the petitioner, i.e. Rasidul Islam Eliz Bhuttu, who is apprehending arrest in connection with Bilasipara PS case number 350/2023 corresponding GR case number 626 of 2023 registered under section 3761/392 of IPC. Stop. Call for case diary fixing on 29/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that the petitioner named above in the event of arrest in connection with the aforementioned case shall be released on interim pre-arrest bail to the satisfaction of the arresting authority, subject of course to the following conditions. Number 1, appearance within 7 days, inducement, similar, refrain similar, list accordingly.
All right, Lord.
Item 16.
to us. Yes, Mr. Ahmed.
May I please your lordship? Lordship, FIR is at page number 18, lordship.
Page number?
18, 1-8.
Yes.
May I read it, lordship? Small FIR, lordship.
Pre-planned manner. Let him appear. Heard Mr. M. Ahmed, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state.
They are all named accused.
State respondents.
Named accused are Milord. Allegation of Milord.
The allegations are threatening and taking money. Let them appear, and if anything comes out, of course, we will cancel the interim. Stop. This is an application under section 438 of CRPC for granting pre-arrest bail to the petitioner in petitioners I 1, 2, 3, 4, 5 and 6, page 2, 3, 4, okay, who are apprehending arrest in connection with Mankachar case number 55/2024, registered under sections 147, 427, 448, 386 of IPC 1860. Stop. Call for case diary fixing on 29/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioners named above, they shall be released on interim pre-arrest bail in connection with the above noted case, subject to the satisfaction of the arresting authority, subject to, of course, to the following conditions: appearance 7 days, list accordingly.
Highly offensive.
Give those conditions. Interior. 17. Call for CD, list on.
My lord.
Mr. Chaudhary, item 17 you are appearing? Call for CD, list on.
19th of April.
19/4/24.
Item 18.
Yes, Mr. Abdullah, 307.
Second application, only case diary at this stage, madam.
Huh?
Only case diary.
Call for case diary, list on.
My lord, 29th.
29, 29/3, 24.
29/4.
29/4. Next.
Can it be a little bit earlier, madam? 29/4.
It's up to Mr. Das.
My 23rd.
23rd of
April.
23/4.
Right, madam.
Please change the stenographer.
May it please your lordship, page 11 is the FIR, my lord.
19.
My lord. Unfortunately,
FIR.
page 11, my lord.
Page 11.
Yeah. In an unfortunate incident, my lord, the informant's daughter, my lord, she allegedly, my lord, committed suicide, my lord. And the incident occurred on 7/3, lord should find from the FIR, my lord. And thereafter, my lord, as for instructions, she died on 15, my lord. My lord, this instant FIR was lodged on 14th, my lord. And with the allegation, lord should find one line, my lord, that 7th line. Later on seeing the mobile phone of my daughter, it came to know that there was love.
Yes, Mr. Das, let him appear. Item number 19. Again, interior. Heard Mr. A. Chaudhary, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for grant of pre-arrest bail to the petitioner, i.e. Nibir Akaz Bora, alias Nibir Bora, who is apprehending arrest in connection with Dergaon Police Station case number 39 of 2024. Stop. Call for CD, call for case diary fixing on
29th of April.
29 4 2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioner named above shall be released in connection on interim pre-arrest bail in connection with the above noted case, furnishing bail bond of rupees 15,000. 15,000. Satisfaction of arresting authority 10 days.
Much obliged, my lord.
Appearance 10 days.
Highly obliged.
I think that is item 10.
May please, Your Lordship. Lordship,
Item?
We have not, 10. Lordship, we have not annexed the entire order, so we may be allowed to bring it on record by filing additional affidavit.
Kindly speak in front of the microphone.
We have not annexed the entire order
Speak
sheet.
in front of the microphone.
Sheet.
Yes.
Lordship, we have not annexed the entire order sheet, so we may be allowed to bring that on record by filing.
Your name?
MSN.
MS?
MSN.
নামটো কি গুডকন না কম্পাউন্ড লিখি দিব MS so and so learned counsel for the petitioner submits that the petitioner may be allowed to bring on additional facts by way of additional affidavit. Stop. Prayer not opposed. Prayer is allowed. Prayer is allowed. List after 1 week on a date to be fixed by the registry.
Item 17, my lord. I was thinking
Order has been passed. Item 9.
May I please, Your Lordship? Lordship, Criminal Division petition, Your Lordship. Here I am the owner of a truck, Lordship. I am the owner of a truck, Your Lordship.
Yes.
Which has been seized, Your Lordship, in connection with a Gulfpur police station case, Your Lordship. Accordingly, we have filed a Jimma petition before the SHM Lordship, Gulfpur Lordship. And my prayer of Jimma has been allowed. But subject to a furnishing of a bank guarantee, Your Lordship, equivalent of my vehicle, Your Lordship. That is my grievance, Your Lordship.
But that is the discretion of the magistrate court, and rightly so, that Sundar Bhai Ambala's case, while releasing a vehicle, a condition of that sort has to be imposed.
Lordship, that condition is there, Your Lordship.
Then?
The thing is that the truck, the value of the truck is 30 lakhs rupees. Amount in rupees, almost rupees 30 lakh, Your Lordship. I'm not in a condition, Your Lordship, to pay that rupees at the bank, Your Lordship, to deposit that much amount in the concerned bank, Your Lordship, so that the bank can issue.
Are you carrying Sundar Bhai Ambala's decision?
It is there, yes. Some conditions.
Show me that. Are you carrying that decision?
No, Lordship. But one, I am carrying the one judgment of this honorable court, Your Lordship, whereby the relaxation, the receipt. Lordship.
Show.
Condition has been exempted, Lordship. Waive, Lordship.
26
It has been relaxed by taking a bond of 50,000 instead of a bank guarantee equal to the value of the aforesaid vehicle.
That can be done. If that is.
No, this is not a precedent. It has been done in the context of that case. But here also, the petitioner has submitted on oath that the petitioner has financial capacity, does not have the financial capacity of producing that kind of a bank guarantee. So, in the peculiarity of the facts, should we relax it? This is what is the question before you, Mr. Das.
That is facts and circumstances of this case. This is not a ratio.
Same case.
So,
that is why even here, the petitioner has made out a case that the petitioner's financial capacity does not have the capacity to fulfill the condition that has been granted.
Your Lordship may suitably modify that condition.
You get the decision of Sundar Bhai Ambala, and thereafter this court will take it up. We're just keeping it for the time being.
Lordship.
Please get that decision.
Supplementary list for motion item 49.
May I please, Your Lordships? This matter was listed for motion in on 29 to 2020.
Counsel, please speak in front of the microphone.
Notices you issued?
When the same was taken up by the Honorable Court, it was pointed out by this Honorable Court that the order of the court should be produced along with the petition so that the matter can be adjudicated.
Yes, have you filed the application?
My lord.
You have
Therefore,
filed?
We have filed on 3rd of March.
Mr. Das, do you have a copy?
No, my lord, I don't have the copy.
You have not given him a copy? It is available.
Brought on record, my lord. Some copy. Chief has mentioned, no? Why court order? Court order copy.
What is your grievance? What is the grievance?
My lord, grievance is that the petitioner is not the name accused person. Her name is not.
You are seeking quashing of what?
Quashing of FIR.
Quashing of FIR and charge sheet.
Quashing of the FIR and the charge sheet, based on which, by order dated 17/11/2023, cognizance has been taken.
My lord.
It appears that as of now that there are allegations, so notice has not been issued. Notice not issued.
Notice.
This court shall issue notice only at this stage.
And in the meantime,
No. Heard Mr.
SK Das.
S.K. Das, learned counsel for the petitioner, stop. Also heard Mr. D. Das, learned APP for the state respondent, stop. This is an application under section 482 of CRPC 1973 for quashing the impugned FIR dated 23/6/2023 corresponding to Hosai PS case number 300/2023 within bracket GR case number 1214/23 registered under section 325/3704/34 IPC, read with section 75 of the Juvenile Justice Act and read with section 14 of the Child and Adolescent Labor within bracket Prohibition and Regulation Act 1986, lodged against the accused number 1 and accused number 2 by the informant, as well as the charge sheet number 325 dated 30/9/2023 registered under section 374/34 IPC, read simply say under 39/23 and stop. Issue notice, returnable 2 weeks. Mr. D. Das accepts notice on behalf of the state respondent, registered post AD in respect of respondent number 2 within a period of 2 days. Notice returnable 2 weeks. List accordingly.
Item 15.
Yes, Mr. Garodia.
May it please your lordships. Lordships, this quashing application.
Quashing of what?
Quashing of this CR case, madam.
Where is it?
CR case, lordships, has been instituted under.
This is under an NI Act.
Under NI Act, madam.
Cognizance has been taken.
Cognizance has been taken, lordships. The facts of the case, lordships, are like this, lordships. That the complainant in the NI case, in the NI Act proceedings, lordships, I had appointed him, my lord, in my company. And lordships, the arrangement was such that lordships, he will get finance for the company, lordships, and he will be given commission. Now, lordships, he has forged the appointment letter. And after forging the appointment letter,
You issue notice at this stage, nothing more.
lordships, will please to see the appointment letter once, my lord.
This is not a case for interim.
Lordships,
There are allegations.
There are allegations, my lord. If I may
See,
just...
this court is not going to embark upon an inquiry about the genuineness of those allegations, correct?
Lordships.
So, only notice at this stage. Heard Mr. P.K. Garodia, learned counsel for the petitioner. Also heard Mr. Is state party? No.
State is a party,
Mr. D. Das, learned APP for the state respondent. Stop. This is an application under... This is a petition under section 482 CRPC seeking quashing and setting aside the proceedings in connection with CR case number 811 of 2022 and the order dated 10/5/2022 passed by the Court of Learned SDJM 2 Kamrup M, taking cognizance under Section 138 of the Negotiable Instrument Act 1881. Stop. Issue notice, returnable 2 weeks. Mr. Das accepts notice on behalf of the state respondent. Extra copies within the course of the day. Steps by registered post in respect of respondent number 2. Interim order shall be considered on the next date. List accordingly.
Lordships will allow dusty service as
Dusty service allowed.
Item 51.
Okay.
In addition.
This is a peerest bail application. 6 petitioners, my lord, all are family members, my lord. Out of, my lord,
AB.
AB, my lord.
FIR.
FIR page 9, annexure 1. Admittedly, my lord, there is a boundary dispute, my lord, and on the day of alleged incident, my lord, there is a scuffle between the parties, my lord. There was nothing serious happened, my lord, only both the sides, my lord, sustained simple injuries, my lord.
You are for the 6 accused.
My lord.
AB is for the 6 accused.
Yes, my lord. 1, 2, 3, my lord, brothers, my lord.
1,
1, 2, 3, my lord, 3 brothers, my lord, and 4, 5, my lord, sons of my lord, petition number 1, my lord, and 6 is the, my lord, wife of petition number 1.
They're all family.
All family members.
Mr. Das, let them appear. Heard Mr. A.M. Borbhuya, Learned Counsel for the petitioner. Stop. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. This is an application under section 438 CRPC for seeking granting anticipatory bail in favor of the accused petitioners, i.e. 1, 2, 3, 4, 5 and 6, Sailoba at page 2, who are apprehending arrest in connection with Algapur PS case number 36/2024 registered under section 141, 143, 448, 326, 427 IPC. Stop. Within bracket corresponding GR case number 258/2024. Call for case diary fixing on 29/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest of the petitioners named above, shall be released on interim pre-arrest bail in connection with the aforementioned case, furnishing bail bond of 15,000, 30,000 each. Satisfaction of arresting authority, subject of course to the following conditions. Number 1, appearance 7 days. Aru baki dutao di dibo, list accordingly.
For admission, item 50.
Lordship, the conducting counsel, Mr. Gautam Chaudhary, is out of station. Kindly.
As prayed for, but this is of 2015.
Scan copy has come.
Interim order is there.
Lordship.
We'll vacate the interim order and we'll give you time then.
Lordship, just a few days time, Lordship, because the conducting counsel is out of station.
You are there.
Lordship, I don't have the brief with me.
Why? You don't have access to the chamber?
No.
You don't have access to the chamber?
It's not like that, Lordship.
Then it is, you see, if you are making a mention of an old matter, then at least have the courtesy of getting the file, having a look at it and then come. You cannot take this court for granted that you seek adjournment and adjournment will be granted to you in a routine manner. Correct? Especially when the matter pertains to 2015 and you are having a stay order.
Lordship, I'm sorry for the Lordship. Just few days time may be granted.
We'll fix this matter for hearing.
Lordship, it's already admitted. Lordship.
Admitted?
Yes, Lord.
Where is the order? It says list the matter for admission.
As per my instruction from my senior, he was suggesting that since the matter has already been admitted, let's let it fix for the hearing. It was the instruction I received today, Lordship.
There is an order that both parties agreed list the matter for hearing, but subsequently there is an order for admission. You see, if you are standing before this court only on the instruction of your senior, right? You could have at least have a look at the order sheet and find out yourself whether the matter has been admitted, not admitted. You would have saved some judicial time of this court. Mr. Das, kindly see if this matter has been admitted. If it has been admitted, we'll post it for hearing. In the meantime, call for the next matter. Wait for some time.
May it please your Lordship.
Yes.
In pursuance to the last judicial order, I have taken steps by memo number 3363.
Services completed?
No, my Lord, it has been returned. In the second file, your Lordship will find it has been returned unserved.
Why?
No, Lord, I don't know, my Lord. This is the second address that we have received and we have sent it. It was sent on 6/12/23. So if your Lordship permits me to send it through the OC of that area, my Lord.
1 second. It appears from the office note dated 29/1/2024 that the notice issued in respect of respondent number 2 by registered post with AD on 6/12/2023 has been received back as unserved without any postal remarks. Stop. Mr. P.K. Roy Chaudhary, learned counsel for the petitioner, submits that he may be allowed to take fresh steps through the jurisdictional police station. Stop. Prayer allowed. List after 2 weeks on a date to be fixed by the registry.
Interim order to contact.
Is it already there?
So, my Lord, 4/11/22. 4/11/22.
4/11/22.
4/11/22, my Lord.
Interim order passed earlier shall continue till then.
My Lord, if your Lordship permits me, can I take back those steps record, or I'll take fresh steps?
Yes. 145%.
Lordship, kindly adjourn the matter for 1 week.
My Lord, I have one humble submission, my Lord.
Who are you appearing for, Mr.
Nawaz? Respondent number 2, my Lord.
Informant?
No, my Lord. This is 145 proceeding, my Lord. So, my Lord, they have challenged the order. My Lord will find the impugn order at page 107, whereby proceedings were initiated and directions were passed in their absence. So, they were aggrieved by that, my Lord. Otherwise, we do not have any objection, my Lord, if this order is set aside and the matter is remanded back. And they may be heard, and then the matter may be decided on merit, my Lord. We are otherwise not.
Where is the order, Mr.
Order,
Nawaz?
Page 107, my Lord.
Page 107,
my Lord.
7. That is the order that they are aggrieved by.
They are impugning 2 orders. First order, my Lord, 106.
Yes.
106 hereby, my Lord. Herein only the parties were restricted from entry or conducting any activity in the scheduled land, my Lord, during the pendency of the case. Second, my Lord, page 107, where the learned magistrate has observed that there is a possibility of breach of peace and tranquility, my Lord, and thereby attachment was
second party absent without any steps. They are the second party.
They are the second party, my Lord.
So they are the accused.
This is my Lord.
Oh, this is proceedings.
Yes. So they are aggrieved that in their absence this order was passed, attachment order was passed, my Lord. So if they want to be heard, my Lord, matter may be remanded back also. We have no objection. If that is agreeable to them.
Your senior is not there today. Why? You said you want some time for what?
Lordship, my senior is in another leg on another court, and Lordship, my senior.
I'm sorry, but I was.
Yes. Mr. Mondal, Mr. Nawaz is submitting that if he has submitted that the grievance of the petitioner is that the order at page 107 has been passed at your absence. So can this court dispose it off with the direction that let the fresh hearing be there, where you appear in front of before the additional district magistrate Hosai, and the matter can again be fresh considered in your presence?
Yes, that is there. But one question, my lord, whether the executive magistrate has jurisdiction to pass such order.
That is also under challenge.
Yes, particular land which is
so basically you are also challenging the jurisdiction of the executive magistrate.
Yes, because the dwelling house is there.
So all right, what is your case then?
Yes.
Mr. Nawaz, please take your seat.
Now, my lord, Lordship kindly see the impugn order. That is at page 106 first.
These are 145 proceedings.
Yes.
Yes, page?
Page 106.
Yes.
She are put up to me, first party present with steps, second party file hazira, but absent physically. First party has claimed that second party is engaging in some activity in the disputed land during pending of the case in this court. Hence, both the parties are restrained from entry or any activity in the disputed land during pending of the case. OC so-and-so is directed to execute the court order and report compliance.
Yes.
Then, next order, impugn order.
Yes.
That your lordship will find is 107. CR put up today. First party appears, second party absent without any steps. First party represented that the second party has violated the order for a status quo, passed from this inn and plowing on the disputed land. Show cause notice to be served to the second party as well as to the OC Murazar police. OC Murazar, the reason why the order has not been executed. There is every possibility of breach of peace and tranquility. After careful consideration and seeing the emergence necessary, I do hereby attach the disputed land under section so-and-so, prohibit the second party to enter into the disputed land.
So you're challenging the attachment?
Yes. Now, but the dwelling houses is there. The magistrate has no jurisdiction to attach such situation. That is one of the contention we have raised here.
You see, land under 145 also includes the expression land, includes buildings. You are saying there is a dwelling house in the land, in the disputed land.
Yes.
So, subsection 2 of 145, the expression land includes buildings. Now there is a dispute, and it appears that that second party, that is the petitioner, had violated the status quo that was granted, and thereafter also did not appear. And in that situation, because of seeing the emergent situation, the magistrate had issued the orders of attachment under section 146. So what is wrong in this?
Yes. Now, my lord, there is an authority, my lord. My lord, it is holding that by the apex court, my lord. The my lord, dwelling houses cannot be attached under this, my lord, situation. Now, can it be, my lord, posted? My lord,
Matter is posted for today. You come before the court without carrying the authorities in your support. Matters cannot be adjourned in such manners, Mr. Mondal. You are a senior member of the bar. You should have carried the authority which is in your support.
Yes.
In fact, from the day one you appear, you take that brief. All authorities which is in your support should be kept by photocopy in the file. What is this?
Can it be posted on Monday, my lord?
Otherwise, if I may submit, my lord, the issue whether, because my lord, if my lord sees the schedule of the land, my lord, in both the orders, my lord, schedule does not mention a dwelling house. Now, whether there is a dwelling house or not, that is a disputed fact, my lord. That cannot be decided in a 482 proceeding, my lord. That has to be agitated before the magistrate. Now, since we are otherwise conceding,
you are otherwise
conceding this part, that since they were absent, these are these issues. The authority which my learned senior is otherwise suggesting, these are issues which can be raised before the magistrate. And since we are considering that this order may otherwise be set aside, so if the order is set aside, the attachment will automatically go, my lord. Let them go and appear before the magistrate and argue this matter, my lord.
That is fine.
So we are considering.
We are not.
All right. Heard Mr. M.A. Mondal, learned counsel for the petitioner. M.U. Mondal, sorry. Heard Mr. M.U. Mondal, learned counsel for the petitioner. Stop. Also heard Mr. S. Nawaz, learned counsel for respondent number
2, my lord.
2. Mr. Das, Mr. D. Das for the APP for state respondent. This is an application under section 482 of CRPC 1973, assailing the proceedings with the MR case number 8 of 2022, registered pending before Additional District Magistrate Hosai, Sankardev Nagar, under section 107/145 CRPC. Stop. The case of the petitioner is that on 10/1/2022, the respondent number 2 has filed a petition before the District Magistrate Hojai, Sankardev Nagar, under section 145/146 CRPC, praying for restraining the petitioner from entry to the disputed land. Stop. By order dated 21/3/2022, the said proceedings were transferred to which court? Was transferred to ACS Executive
Magistrate.
ACS Executive Magistrate for disposal. Stop. Thereafter, notice was issued by the Executive Magistrate under section 107/145 CRPC to the parties for appearance. Stop. By order dated 13/4/2022, these orders are not required. Thereafter, you see, thereafter when the matter was put up before the executive magistrate on 10/3/2023, the petitioner, the respondent number 2 was present while the petitioner appeared through appearance sleep.
Yes, madam. But he was not physically present. He was not physically present, madam.
Without being physically present. Stop. Considering the submissions of the respondent number 2 that the petitioner is engaging in some activity in the disputed land during pending of the case in this before the court, the executive magistrate, the jurisdictional executive magistrate directed that
Case 106.
Directed that the parties shall be restricted from entering or carrying activity in the disputed land pending disposal of the case. Stop. Subsequently, the matter came up on 17. The date is not legible. 17?
17/7/2023.
17/7?
Yes.
17/7/2023 before the additional district magistrate. These proceedings are going on before where? Before the executive magistrate or additional district magistrate?
Last order was passed by the additional
Correct.
district magistrate, ADM.
Before the additional district magistrate, wherein Magistrate district Hojai, comma, when the petitioner was absent without any steps. Stop. It further appears that on that date, after considering and seeing the emergent nature and the possibility of the breach of peace and tranquility, and also for the fact that the respondent number 2 has violated the order of status quo.
The petitioner.
Petitioner has violated the order for status quo passed earlier, directed attachment of the disputed land under section 1461 CRPC. Stop. Mr. S. Nawaz, learned counsel for the respondent number 2, concedes that fairly submits that he has no objection if the attachment is kept in abeyance and the matter is remanded back to the additional district magistrate to consider the matter afresh in presence of the both parties. Stop. Accordingly, this court, for the ends of justice, is of the considered view that this criminal petition can be disposed of with the direction that the additional district magistrate shall reconsider the matter afresh in the presence of both parties. Stop. When should you all appear? Within
a month, madam.
Accordingly, parties are directed to appear. Give a date.
Yes. 19th of April, madam, if possible.
Appear before the additional district, before the court. Before the court of additional district magistrate Hojai on
19th of April.
19/4/2024. Stop. As and when. Stop. Needless to clarify that upon appearance on the date fixed, the court of additional district magistrate Hojai is at liberty to proceed in accordance with law. Stop. Registry to intimate the order of this court by email. LCR is here? No. Any documents? I think LCR is there. Send LCR back. With the aforesaid observation, this criminal petition stands disposed of.
But the impugned order may be interfered with. Otherwise, the impugned orders here may kindly be interfered with. Otherwise, there will be.
To that extent, the order of attachment is set aside and quashed.
Captain Abeyance, my lord has already observed.
I'll edit it.
Unless
I'll edit that part.
Deeply obliged, my lord.
May please lodge.
Yes.
Here, my lord, we have silenced, my lord, the order of cognizance, my lord, as well as the charge sheet, whereby, my lord, section, my lord, has been added. Here, my lord, the FIR was filed, my lord, on.
Scan copy of LCR was called. I don't think it has come. It has not come. Await scan copy of the LCR. Stop. List on.
After review, your lordship.
After 4 weeks on a date to be fixed by the registry. Yes. What is this appeal? POSCO.
Lordship, the appeal is, lordship.
Notice not issued to the informant.
Lordship.
However,
we have received the case.
Thus,
I have gone through the order sheets. My lord, first notice took number of
appeared.
The numbers.
Huh?
8/9/2018. I have flag mark, my lord, pink flag mark. Then, my lord, your lordship may kindly see, my lord, on 9/11/2018, he again took time.
Yes.
Then subsequently on a
yes.
Hearing could not take place. My lord, told us.
London. Next para. Miss MS so and so G Chaudhary
Is out of station.
the stay order on way with the trial court in pursuant on number of occasions the petition. Other cases.
My lord.
There was a submission made, however, on scrutiny of the order. No further adjournment of the matter that on 9/9/2015 shall not hit. The interim order passed by so till after 2 weeks on a date to be fixed by the registry.
Much obliged. That judgment, your lordship. And that page number, that your lordship, more than sometime 4 months, 5 months, more than.
What is it? Can you read it, please?
Yes, your lordship. There some appropriate condition they can impose. Yes.
Below 14, can you see vehicles? Can you see? So this is
a number of vehicles are kept and attended, and vehicles become junk said vehicle if required by the court at any point of time.
In our view.
In our view, what if for return of the said vehicles if required at any point of. Now, your lordship.
The order, your lordship may direct that all upon.
So we remanded.
Bond has to be executed there only.
Correct.
So we get over the vehicle, lordship, by furnishing instead of the bank.
Equivalent to the value of the vehicle.
That is why bond or bank guarantee is required.
Of what rupees?
20 lakhs.
Hurt MSG motion under section 397/401. Stroke cancel. Additional Judicial Magistrate Gaupur PC read with section 11 ABC directions were given of the face of the value of the aforesaid vehicle. Stop. Condition virtually amounts to consider for ends of third view that the order dated give a bond stop. With the above direction, the present the trial is the magistrate power they have exercised. Guarantee bond. Only that much. 04.
Yes, Lordship.
Where is the case?
Succumb to his
Mr. Par-
along with that disease, some conflict was there. He kicked the person assaulted. Altercation was there.
Yes, but he
43 days. 43 days.
43 coming towards me because there is a separation. You have to point.
SD Roy, Your Lordship.
Mr.
SD Roy.
439 of CRP with Dispur PS case number C. Stop. The case of the prosecution last night at about 10 p.m. her succumbed to the said injuries. Stop. Learned APP for the state respondent submit reveals, don't say that, son, reveals that it appears that the investigation is materials collected by the, don't say considering, as such this court ordered that the petitioner named above shall be.
Here, my lord, with all respect, my lord, diary has possibly come. Here, my lord, offence should be possibly, my lord.
376.
376, 511, my lord. Possibly, my lord, it would be a case under 354-1.
Petitioner, my lord. And the only allegation in the FIR, my lord, the present petitioner she bite in the lips of the informant, my lord. And that is the only allegation against the present petitioner, my lord.
Husband, wife?
No, my lord. No. They're tenant in the campus, my lord. The informant and her husband and the present petitioner and her husband also stayed in the said campus, my lord.
Yes, Mr. Parashar.
My lord, at about 9:30 p.m. But that accused petitioner, my lord, along with another lady, my lord, they both drank, and in drunken condition, reviewed the, my lord, husband of the, my lord, victim in filthy language. Husband reviewed the husband of the victim in filthy language. At that point of time, the husband requested the house owner.
I've seen that.
Stop. Because of that, my lord, the petitioner and her husband entered into the room of the victim. Husband of the petitioner assaulted first to the victim in her stomach, kicked in her stomach, and she
beat her.
Yes, during the she bite in the lower lips, and taken a portion of the lips,
There is, is there any adverse antecedents?
She is, medical report is there, yet a portion of the lips taken away by biting. And she is appearing for the informant, one photograph, not in the CD, she has placed.
It's all, photograph is not required, it is the lips.
Lips, yes.
The issue is whether further detention is required or not. That is the issue before this court. Correct. Now, is there any, how many days?
19 days.
19 days. And what about the antecedents? Because it appears that while intoxicated,
intoxication condition that is there, and there are other tenants in the same campus. There are other independent witness also, and statement of the owner of the house, that lady. He also stated that she is in that condition. She is there.
So it appears that the incident occurred, correct? Yes, now the question is therefore detention. That is why the question I am posing before you is whether you need him for further detention, because it appears that statements have been recorded. The accused, the petitioners have also been interrogated, and the allegation you have seen.
I have objection in such type of cases. I have objection regarding 19 days. This of course a statement recorded.
Now your objection is taken note of, but this court has to also judicially consider everything and see whether the liberty needs to be further detained. Correct? Because the question of liberty is involved. If there are any materials in the case diary to show that the petitioner has past adverse antecedents, or that the petitioner is likely to flee from justice, then of course. Otherwise, bail is not punitive, isn't it? Nothing else.
She is appearing for the informant.
Come in front of the microphone.
My Lord,
You are for the informant?
Yeah. My Lord, the accused and her elder sisters both went to the victim's room and they have threatened it.
Yes, Miss Counsel, this court is not doubting the allegation. What this court is saying is that, if assuming those allegations are true, bail is not punitive. Correct? The object of bail is to secure the attendance of appearance of the accused by a reasonable amount. Only to that extent. All right.
I will file objection, Lordship. Kindly consider some time.
You have a participatory role. What objections can you have already appeared? This is item number
29.
Heard Mr. S.A. Hussain.
My Lord, DJ Halloway.
Heard Mr. D.J. Halloway, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent, and M.S. G. J. Bormon, learned counsel, appearing for the informant. Stop. This is an application under section 439 of CRPC 1973 for grant of regular bail to the accused petitioner Julie Das. Petitioner is one. Petitioner Julie Das, who was arrested on
My Lord, 3/3/2024.
3/3/2024 in connection with POSCO PS case number 132/2024 registered under section 294, 448, 323, 354, 326, 34 of IPC. Stop. The case of the prosecution is that on 2/3/2024 an FIR was lodged alleging inter alia that on 1/3/2024 when the informant and her husband was in her rented house, the tenant of a neighboring compound, namely Rakesh Das and his wife, within bracket petitioner herein, started yelling, abusing in drunken condition, and when the informant's husband called the owner of the house, of the said house, to complain about them, the petitioner entered into the informant's room and dragged the informant's husband out from his room and started to assault him. Stop. It is the further case of the prosecution that when the informant came to save her husband, the accused petitioner suddenly kicked her and
husband of the petitioner.
Husband of the accused petitioner.
Husband of the accused petitioner.
It is further, Jakula, when the accused, when the husband of the informant came out to stop her, she kicked him on.
No, my lord. The informant.
She kicked him on the belly.
Yes.
She kicked him on the belly. Stop. It is the further case of the prosecution that the petitioner also pulled the informant in the dark place and bitten on her lips. Stops. Mr. Next. Mr. DJ Halloi, Learned Counsel for the petitioner, submits that the petitioner is no way involved with the offence alleged and has been falsely implicated. Stop. He further submits that the allegations made in the FIR are afterthought. Stop. He further submits that the petitioner has no previous bad records and no criminal case is pending against the petitioner. Stop. He further submits that there are no chance of the petitioner absconding and or fleeing from justice. Stop. Next para. Mr. K.K. Parasar, learned APP for the state respondent, strongly opposes the prayer for bail. Stop. He submits from the materials available on the record, especially from the case diary, that there are materials implicating the accused for the offence alleged. Stop. He further submits that the statements of the witnesses and the victim.
Yes.
Statement of the witnesses and the victim and the accused has already been recorded under section 161 CRPC. Stop. He submits that from the statement of the witnesses, it appears that there was that the petitioner has assaulted the victim. Stop. MS so-and-so, learned counsel for the informant, has also submitted before this court that the accused petitioner has assaulted the victim in her lips grievously by biting. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that there are materials implicating the accused for the offence alleged. Stop. It further appears that the investigation has substantially progressed. Stop. It appears that there are no materials available on the case diary to indicate anything adverse as regards the antecedent of the petitioner. Stop. Further, there is nothing available in the records to indicate that the petitioner is likely to flee from justice. Stop. It is well settled that bail is not punitive. Stop. The object of bail is to secure the appearance of the accused by a reasonable amount. Stop. Stop. As such, this court, no, you just change para. Considering the facts and circumstances of the case vis-a-vis Article 21 of the Article of the Constitution of India, this court is of the considered view that further detention of the petitioner may not be justified for the ongoing investigation. Stop. Accordingly, it is provided that the petitioner named above shall be released in aforementioned case, bail bond of rupees 20,000. Satisfaction of CJM Kamrup Metro. Following conditions. With the aforesaid direction observation, this bail application stands disposed of.
Highly obliged.
Item 30.
30 malat CD not received, madam.
Not received.
Kindly fix a short date, madam. It will come from Jalukbari.
Awaits case diary.
28 malat.
28-3. Fix on 28-3-2024.
Deep level.
Item 31.
May I please, Lordship? It's a 439 application.
302 case diary.
Received, madam.
Yes.
Lordship, from the allegations in the FIR, Lordship, there's a case of 306, Lordship, not 302. Because The FIR at page 7, Lordship.
Suspected
To be hanged.
a scale because she was found hanging.
Yes.
Yes, my lord. He's the husband, my lord. He is outside. He's in Guwahati, my lord. Incident occurred in village, my lord.
The accused at that time was in Guwahati at the time of the incident.
Yes, my lord. And only the disease and her, my lord, 6 years girl were there in the, my lord, house, and she was found hanging. And as per PM report, my lord, yes, death was due to combined effect of especially following the hanging during life. So, my lord,
okay.
My lord, witness neighboring people also said that only the girl and the disease were there in the house, my lord.
You are Mr.
M. Ahmed.
M. Ahmed. Heard Mr. M. Ahmed, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent. Stop. This is an application under section 439 CRPC for granting regular bail to the petitioner, i.e. Saiful Islam, who was arrested on 19/1/2024 in connection with Dhula PS case number 7 of 2024, registered under section 302 IPC. Stop. The case of the prosecution is that on 19/1/2024, a FIR was lodged alleging that the wife of the accused petitioner was found hanging inside her room on 17/1/2024, and accordingly it was suspected that the lady has killed herself. Stop. Mr. M. Ahmed, learned counsel for the petitioner, submits that the petitioner is no way involved in the aforesaid in the alleged offence, and that the petitioner was not in the village on that night, on the day of 17/1/2024. Stop. Mr. K.K. Parashar, learned APP for the state respondent, submits that the materials available on the record, especially case diary, indicates that the petitioner was at Guwahati during that time. Stop. He further submits that the medical post-mortem report reveals that the cause of death is due to hanging.
Hanging during
is
life.
due to hanging
During the lifetime.
Huh?
During hanging, especially following hanging during life.
Is due to asphyxia hanging. Stop. I have perused I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears that the investigation has substantially progressed. It further appears that the statements of the witnesses and the petitioner has already been recorded under section 161 CRPC by the investigating officer. Stop. It further appears from the statements of the witnesses that the petitioner was not present during the time of the incident. During the time of the incident. Stop. During the time of the incident. Stop. It further appears that the post-mortem report is negative as regards the allegation under section 302 IPC. Stop. Considering the aforesaid facts and circumstances, this court is of the opinion that further detention of the petitioner is not justified for the ongoing investigation. Stop. Accordingly, bail granted. Bail bond 30,000 satisfaction.
CGM
CGM
Dorong at Mongol.
CGM Dorong, Mongoldoy. Conditions. With the aforesaid observation, disposed of.
I am obliged.
32, my lord.
32, my lord. The IO of the case has informed my office that it is on the way. The case there is on the way. Could it be taken up at 2 p.m., my lord?
Supplementary list, bail hearing item.
Okay. 52.
May I please your lordship?
31, 32. Yes.
Lordship, the case.
CD? LCR was called?
Yes, lordship.
LCR, not, unfortunately, I could not go through today. Key offense. Could it be taken after, sir? At 2 on
At 2.
After vacation. On 28 or 29?
27?
27.
In item number 52.
52.
In item 52, we'll list this matter on 20, as prayed for, list this matter on 27/3/2024.
Item 33.
Lordship, up-to-date CD has not been received.
CD not received, my lord.
Await up-to-date CD? CD or up-to-date CD?
Up-to-date CD.
Await up-to-date CD. List on? Interim, interim order, if any, shall continue till then.
On 9th, my lord.
9/4. CD?
34, my lord, also not received.
But this is the 5th occasion when CD.
You are on interim.
Yes, Lordship.
Yes, my lord. Well, for a 5th occasion, we have sent the signal, but CD not provided.
Await CD. Interim order passed earlier shall continue till then.
On 19, my lord.
List again on 19/4/2024.
Obliged.
34 bola.
Lordship, the
CD?
CD available.
Yes.
FIR is Lordship, page 11, Lordship.
Page?
11, Lordship, translated par Lordship. I am not in the FIR name, Lordship. My name is not in the FIR, Lordship.
Sorry?
My name is not in the FIR, Lordship.
Your name is not in the FIR.
Yes, Lordship. I am not collected here, Lordship.
One thing is that my lord, interim granted on 1/3/24, but here CD is up to 8/24. Their statement is also not available in the CD.
Then get the up to date. He is already on interim. You are already on interim.
Yes, Lordship.
All right. It is submitted at the. It is submitted by Mr. K.K. Parashar, learned APP for the state respondent, that though the CD has been received, but the up-to-date materials are not available. Up-to-date status is not available in such in the CD received. Stop. Accordingly, call for up-to-date CD. List again on
23rd of Malak.
23/4/2024. Interim order passed earlier shall continue till then.
Item 38.
38, my lord.
FR 38. Heard Mr. P.J. Datta, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APP for the state respondent. Stop. It is submitted by Mr. K.K. Parashar, learned APP for the state respondent, that the FR has been submitted. Wide.
FR number 02/.
FR number
02/2024. Dated 31/1/24.
Dated 31/1/2024. Stop. As such, the interim pre-arrest bail order granted by this court-wide order dated 5/2/2024 is hereby made absolute. With the aforesaid observation, this anticipatory bail application stands disposed of.
Obliged.
Item 40.
Right to reason. Before starting, my lord, there is a notification. 40.
In 40, you are for the informant.
There is a notification by the Guwahati High Court that in the case of 376, the victim is to be made party. So, my lord,
Victim to be made party or copy to be served?
My lord. No, my lord, not copy to be served.
Are you referring to the decision
notification,
of...
my lord,
Huh?
notification dated 15 March 2024.
Please show.
Yes.
Notice to be served.
Notice to be served. I don't think impleadment, because you see, Mr. Counsel, there is under CRPC, there is no provision for impleading the informant. The role that has been now made, the role that is...
I am reading the notification.
Yes.
Peruse to the order dated 23/6/2023, passed by the Honorable Guwahati High Court in criminal appeal number so and so. The Honorable Chief Justice has been pleased.
Mr. Counsel, I am aware of this notification. We have been passing orders on a number of occasions. This is in reference to that case of Deepak Nayak. You kindly come to paragraph C. In every bail application, criminal appeal, criminal revision, criminal petition. Sir, this is relating to offences under POSCO serve such bail application. But however, there is a...
Now your lordship will see C2, Roman 2, C Roman 2 of the notification.
Implead the victim. As per
Implead the victim. C1, my lord. Concern the officer in charge of Bharnikula police station through email the victim. Now
is this a matter pertaining to POSCO?
Roman 2, my lord.
376.
In
Not
every
POSCO.
bail application,
But
in every bail application, criminal appeal, revision, criminal petition filed in the Guwahati High Court, it shall be mandatory to implead the victim, guardian, support so and so as the case may be while making such impleadment identity of the victim so and so. So victim is to be made party. So my lord, here in this case, my lord.
This is 438 or 439?
It is 438, my lord. 438 petition.
438, and it is a case of 376.
My lord.
Yes, my lord. So, my lord, my humble submission, I have filed a impleading petition. So that may be tagged with the case, my lord. Tagged with the case, and another day it may be filed. Case has been already numbered.
You see, Mr. Counsel, there is no difficulty to allow you to participate in this anticipatory bail application. This court has already disposed of a case, similar case, because under section 439, please have 439 of CRPC, the proviso. Under that proviso, this participation right has already been given to the informant. It says, provided further that the High Court or the Court of Session shall, before granting bail to a person who is accused of an offence triable under subsection 3 of section 376 or so and so, give notice of the application for bail to the public prosecutor within a period of so and so from the date of receipt of the notice of such application. The presence of the informant, subsequently it says, the presence of the informant or any person authorized by him shall be obligatory at the time of hearing of the application for bail to the person under subsection 3 of section 376. So a participatory role is already envisaged in case of regular bail. Then thereafter there are decisions of the Delhi High Court where this has been extended to anticipatory bail also. But these are participatory role. And this notification where the word implead is...
Pleased to see the notification.
Yes, but
C2.
You see,
C Roman 2.
Mr. Counsel, kindly hear what the court is trying to say. Kindly come to the clause C.
Clause C, yes.
Offences under what? Kindly see, offences is for which category?
My lord, C.
Which category offences?
Sharp copy to the bail application.
No. On top, C. You are reading Roman 2, but Roman 2 is in connection with C. C is for which offences?
Yes. Now your lordship will...
For which offences?
Skip to 2, my lord.
Mr. Parashar, please.
2 is under C.
C is for which offences? Mr. Parashar, which offences?
POSCO Act and those covered by section 439 1A CRPC. The registry shall.
So this is...
Now, my lord, now on C, my lord, 2, Roman 2.
You have filed an impleading application?
My lord.
Where is it?
Every SAS.
Mr. Counsel, where is the impleading application?
Not before.
Yes, my lord. It is filed, my lord.
Where is it?
Also.
Where is it?
It is not placed, my
It's
lord.
not recorded.
Not on record.
All right.
That is why, my lord, that may be
List
placed on
this
record.
matter along with the impleading, along with the IO
IA, my lord.
number.
IA criminal number 2612.
Please give the number
Two,
along
I will
with
give.
so and so on.
2612.
When do you want it?
My lord.
When do you want it?
Day after tomorrow or my lord, holiday.
Date.
Not on 28th, then 1st of April. my lord. 1st of April.
I'm not on record.
1st of April.
We are fixing it on 1st April because the informant has filed an impleading application which is not on record. 1/4/2024.
1st of April, my lord.
All right.
Oblige, your lordship.
Item 41.
May it please your lordship.
Yes.
My lord,
Yes, Ms. Som?
yes, my lord, this is 438 application. My lord, although my lord honest confession of the petitioner, my lord, although my lord he is not named in the affair, but in the altercation in the that move lordship, he was there, and the instant instigation and provocation lordship. Some this
FIR, Ms. Som.
yes, lordship placed him in the affair at page.
Yes, page 10.
Page
19.
Page 12, lordship.
Yes.
I have the honor to report that today at about 2:10 a.m. an information was received from so and so about the assault incident which took place at Okoha village. Accordingly, I say so and so. Staff visited the place of occurrence.
Which page are you reading, Ms. Som?
Som?
Which page are you reading? Page 14 is the FIR, isn't it? Dated
Yes,
7/2/24?
Yes, lordship.
And you are for which accused?
I'm here, lordship. This petitioner is not named in the affair, lordship, because it was a public mob and around hundreds of people were gathered. And my contention, lordship, a very honest submission that he was there. He instructed me. He was there even at the instant provocation and that instigation of this altercation and cross repercussion. He also participated, lordship. That is my but nothing was intentional, lordship.
Yes, Mr.
All
Das.
these things, lordship.
My lord, the eyewitness says, my lord, he inflicted injury by, my lord.
No, any role attributed
Yes,
to the present petitioner?
He says, আমি তেওঁলোকক বহুত বুজাব চেষ্টা কৰোঁ মানে some people gathered, কিন্তু কঞ্জিত কলিতাই মোৰ সন্মুখতে কাঠেৰে মাৰি থকা ল'ৰাকেইটিক বাৰে বাৰে কোবাইছিল.
No, that is before us is Aftab Ali. Anything against Aftab Ali?
No,
কঞ্জিত কলিতা.
Kanjit Kolita. I'm appealing for Kanjit Kolita, lordship.
No, that is why I was.
Item
putting the
41.
bhul dilane ki. Your item number is 40?
41.
Yes, 41, but a wrong, different AB is given. This is AB. It was 651 of 24. 653. Wrong file has come.
Lordship.
After only,
Lordship picks up and
after only the 40 item number.
Check 40. Check the file of 40.
After only the CDS do. Going on again?
Yes, that is the file. Kanjit is 41.
Kanjit Kolita to 41.
41.
Lordship would be pleased to find the affair at page 12.
Very serious allegations, Ms. Som.
Lordship, what is my contention, Lordship? In the same context, Lordship, other petitioners were given interim protection.
But we don't know what are the materials collected against them. Against you, you have heard there are.
Lordship, that is
Yes, Mr. Das, what is available in the CD?
No, eyewitnesses have said, Milord, about
Eyewitnesses have said what?
And out of them, Konjit Kolita and Tiken Das, they are identified by this eyewitness.
And he has assaulted.
And he has assaulted, Milord, the vehicle was set on fire.
And what is the stage of investigation?
My lord, investigation is on, Milord. Or maximum people are, Milord, absconding, Milord.
Lordship, may I call for
the not this case.
up-to-date status, Lordship.
Hmm?
Up-to-date status, may we call for Lordship?
Not at this stage.
After
Sorry, Ms. Som. Heard MST Som, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for the state respondent. Stop. This is an application under section 438 of CRPC for granting pre-arrest bail to the petitioner, i.e. Konjit Kolita, who has been apprehending arrest in connection with Nalbari PS case number 32 of 2024, registered under section 120B, 143, 144, 341, 326, 307, 436, 353, 42, 427 of IPC. Stop. The case of the prosecution is that on 31/2024, an FIR was lodged alleging that on 31/2024, four persons who were sitting inside the car were badly assaulted by the villagers with bamboo stick and lathi with intention of killing them in suspect of cow theft. Stop. It is further alleged that the police personnel were also attacked and the government vehicle was damaged. Stop. MST Som, learned counsel for the petitioner, submits that though the petitioner was present in the place of occurrence, but he has not participated.
Lordship, participated at the provocation and instigation of some leaders.
But he had participated in the though he was present in the place of occurrence and participated in the alleged offence, semicolon. However, he did it at the instigation
and provocation of some leaders.
At the instigation of other co-accused. Stop.
One more word, Lordship. In fact, he can be the witness for the state, Lordship. From that, state is going to get benefit if.
He further submits that he is willing to be a state witness. Yes. Stop. Mr. D. Das, learned APP for the state respondent, submits that the materials available in the case diary indicate that the petitioner has actively participated in the offence alleged. Stop. He further submits that there are statement of co-accused recorded under section 161 CRPC by the investigating officer.
Not witnesses.
Huh?
Not co-accused, witnesses.
Not co-accused, witnesses. Recorded under 161 CRPC by the investigating officer to the who have stated that it is the petitioner who has beaten, who has assaulted the victims and put the government vehicle on fire. Correct? Stop.
Not government vehicle, but their vehicle.
And put their vehicle on fire. Stop. He further submits that there are more people involved in the alleged offence. However, they are all apprehending. Stop. Absconding. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the materials available on record that the petitioner has actively participated in the alleged offence. Stop. It further appears that the petitioner, along with other accused, are absconding and has not participated in the ongoing investigation. Stop. It further appears that in order to unearth the truth, the custodial interrogation of the petitioner is utmost essential. Stop. As such, the prayer for anticipatory bail at this stage stands rejected. With the aforesaid observation disposed of.
Deeply obliged, Lordship.
Item 42.
May I please, Your Lordship? Lordship, 438 application, my lord.
42 minute case there is there, my lord. Mr. K.K. Professor has examined this.
At 2.
Well, at 2.
Item 45.
Yes, Mr. Khanikar, why is this for order?
Well, LC has been called for matter, that was received, madam.
LCR isn't it?
It's a petition, madam.
LCR has come.
LC has come.
What about the service of respondent?
Service awaited, madam.
Still awaited. Await service report. Stop. List again on. After 2 weeks on a date to be fixed by the
Next
registry.
date fixed on matter 13, madam.
Huh?
Next date fixed on matter appeal 13, madam. 14, madam.
List again on. Give a date.
Madam, May, madam. Appeal, madam. 4.
4
Photo appeal.
on 4/4/2024. In the meantime, the LCR call for has been received and is retained in the file.
Item 46.
Yes, what is this IA?
We have filed an affidavit, which is referred today.
You have filed an additional affidavit.
In IA number 189.
What is the IA?
IA for we have filed an IA interrogatory application due to warrant has been issued in the petitioner, and the petitioner appeared before the trial court and submitted to 25,000, and trial court recalled the warrant.
Because you were absent,
And in our
DA was issued. So you by what is the IA for recalling of which order?
recalling the
Judgment lordship.
order dated,
Maintenance judgment lordship.
IA for order dated
And lordship, one IA.
You are not prepared.
25/1/2024 order dated
Passed by SDGM.
by the SDG.
And what is the criminal revision petition?
We have sentenced the for maintenance order passed by the Lanet Court below.
Where is that order?
That order dated order in case number 52.
Huh?
In your revision, case 52.
Who are you? You are for?
Wife.
For the wife.
Wife lordship. Till that lordship, only 25,000 deposited lordship. Already the
The
judgment
criminal
is passed already
revision
1 year
is
gone.
for challenging the final order.
Final order. It is
Maintenance.
It is monthly 5,000.
Huh?
Monthly for 5,000.
Monthly 5,000 and the litigation cost of 30,000.
This has not been paid.
No lordship.
Was there a stay order?
Lordship.
There was a stay order.
Only 25,000 pay lordship. Till date.
And now what is it? What are they seeking by this IA? This is not
One
clear.
IA lordship, one IA number 147.
Yes.
I filed for the pay the maintenance.
Maintenance.
Outstanding.
And then any order passed.
No order.
And in 189?
189 is our IA.
For stay.
For
recalling the order for warrant.
On what ground?
Kindly matter fixed for hearing. My senior is today available.
You should have said at first, why are you wasting the judicial time of this court? As prayed for, list this matter.
On 8 Lordship.
8/4/2024. Yes, Mr. Datta?
My Lord, one request to your Lordships. In the morning, my Lord, I took leave from the Honorable Justice P.J. Sheikha for moving a matter. My Lord, the registry has informed me that similar, out of that affair, there was another case was disposed of by this Honorable Court. Therefore, in terms of the appeals court judgment, my Lord, should be placed before your Lordship.
When do you want?
My Lord, at 2, if your Lordship is kind enough.
Try. All right, Mr. Datta.
Obliged.
Yes.
May please your Lordship. I'm very sorry, that day I have wrongly submitted the court's name as additional session judge Nagaon. It ought to have been subdivisional judicial magistrate Koliabor Nagaon.
This is a IA.
I'm very sorry, I have wrongly
for correction.
For correction. Only that much, Mother.
It has to be
Subdivisional Judicial Magistrate Koliabor Nagaon.
instead of FTC Nagaon.
Nagaon. I'm very sorry, Mother, that day I have submitted one.
Steno is not there. Can we pariba? A lot of problem going on for stenographers. There are times when I'm sitting inside idle doing nothing and there is no steno to give dictation. I'm waiting and there is no one. This is item number
53.
53 of the supplementary list. List 53. Heard Mr. S.M. Abdullah P., Learned Counsel for the petitioner, stop. Also heard Mr. K.K. Parashar, Learned APP for the state respondent. This is an application for correction in the order dated 14/3/2024, wherein the petitioner was directed to appear before the court of Additional Session Judge FTC Nagaon instead of Subdivisional Judicial Magistrate Koiliabor Nagaon. Stop. It is submitted at the bar that the case against the petitioner is presently pending before the Court of Learned Subdivisional Judicial Magistrate Koilabor, Nagaon, and hence to that effect the order dated 14/3/2024 is required to be modified. Stop. For the ends of justice, the order dated 14/3/2024 passed in AB number 682/2024 is modified to the extent that the petitioner modified to the extent by directing the petitioner to appear before the Court of Subdivisional Judicial Magistrate Koilabor, Nagaon. Instead, I don't think that is required to mention. Is it required to mention instead of? Instead of additional session judge FTC Nagaon. Stop. With the aforesaid
extension also be required because 14/24 is
sorry, Mr. Abdullah.
A little bit extension also.
Specific?
Little bit extension of time. 10 days will over on
tell me.
And another 10 days.
Within 10 days from today. With the aforesaid observation, this IA stands disposed of.
Obliged, the same order will follow. When there was a 10 days protection. In the earlier order, Lordship's order, there was a 10 days protection.
Until then, the interim order granted earlier.
In AB number 6, in AB number 682 shall continue.
One sec. Actually, AB number 682
of 24.
Until then, the interim order passed in AB number 682/2024 shall continue.
Deeply obliged, my lord.
My lord, Article 32, so I was anticipating, my lord, the case they will be reaching, my lord. But just now I have received one communication from the officer in charge of the police station that, my lord, the concerned IO is out of station in connection with a, my lord.
My lord, can I pray for interim, my lord? Kindly see in this case.
It's a bail.
Yes, my lord. Kindly see the age.
When?
My lord.
My lord.
My lord, can I? My lord. There is a
29th of April.
Can I make a prayer?
No. If 29 April, then we will have to consider the interim.
Kindly, my lord.
Give a short date.
Your holidays are here, my lord.
Mr. Chaudhary.
My lord, I'll just, my lord, with all respect, my lord.
Mr. Chaudhary, 1 second.
My lord. Lord, kindly hear me, my lord, once, my lord. Kindly.
আজি কিমান তাৰিখে?
বন্ধ আছে ন 27 28
বন্ধ আছে ন
27 আৰু 28 বন্ধ আছে নেক্সট হলে 27 আৰু 28
The first week of April is very busy.
No, that doesn't mean a liberty of a person is also concerned.
Yes. Let it be 5th of April.
Call for CD list on 5/4/2024. There is already a judicial order, Mr. Chaudhary. Sorry.
There is a judgment.
We've given you a short date.
Then on 27, with all respect, kindly, my lord, because
27?
19 years boy, my lord.
27?
And no offense itself.
I'll try.
All right, 27.
My lord, highly, no offense, my lord.
27/3/24.
And there was a judgment of the Apex Court also, my lord. On that
You see, you have not got it on the first day, so you wait, let the CD be produced.
My lord.
You save your energy till then.
Only thing, my lord, 18 years plus, my lord.
All right, next.
Obliged, my lord.
Yes.
Lordship 438 application, madam. FIR is at page number 11, madam.
Case diary there?
Yes, madam. Received.
My lord, the sections which are alleged against the petitioners are 498, my lord, 326, 307, 506, and 34, my lord. My lord, the complainant's husband, my lord, he has been behind bars, my lord. My lord, the complainant's husband, my lord, he is behind bars. My lord,
He is?
He is behind bars.
Behind bars?
Yes, my lord. And my lord, we are praying for the family members of the petitioner, my lord.
My lord, the husband already arrested. This is my lord, father-in-law, brother-in-law, and sister-in-law.
Complainant's husband or petitioner's husband?
My lord, complainant's husband, madam. I apologize.
Complainant's husband.
My lord. And they have earlier they have appeared.
Oh, so husband and wife?
Yes, my lord. These petitioners are father-in-law, brother-in-law, and sister-in-law.
All right.
They have father-in-law and brother-in-law already appeared earlier. Their statement already there.
And the husband has already been.
Allegations is against him, and he has cut.
And the husband is already on bail?
Yes, no, my lord. He is on bail, custody, my lord.
He is in custody. Main allegation is against the husband.
My lord.
And the petitioners are the family members of the husband?
My lord.
Okay. You are Mr.?
P.H. Kaur, my lord.
Heard Mr. P.H. Kaur, Learned Counsel for the petitioner, stop. Also heard Mr. K.K. Parashar, Learned APP for the state respondent, stop. This is an application under section 438 of CRPC 1973 seeking anticipatory bail to the petitioners I, 1, 2 and 3 at page 2 who are apprehending arrest in connection with Pragjyoteshpur PS case number 39/2024 registered under section 498A 326 307 506 34 of IPC. Stop. The case of the prosecution is that the informant's husband stroke co-accused on 3/3/2024 took up a sharp weapon and tried to end her life. Stop. It is the further case of the prosecution that the informant's husband tried to cut her in her right as well as left hand and on other parts of her body. Stop. It is further alleged that the petitioners, not the petitioners, the informant's in-laws, Ashotosh, who is Ashotosh before this court? It is further alleged that the informant's husband's family also mentally tortured her on the pretext of on demands of money. Stop. I have heard the Mr. Your name?
P.H. Kaur.
Mr. P.H. Kaur, Learned Counsel for the petitioner, submits that the petitioners are the family member of the husband of the informant and has no role to play in the offence alleged. Stop. He further submits that the husband against the husband of the informant against whom the main allegations are given is already enlarged on bail by this court. By this court?
He's not.
He is already in custody. He is already in custody. Stop. Mr. K.K. Parashar, Learned APP for the state respondent, submits that there are no materials against them.
Sufficient materials.
That the informations collected by the IO at this stage does not indicate any adverse materials against the petitioners. Stop. I have considered the submissions made at the bar and have perused the materials available on record. Stop. It appears that there are no adverse materials at this stage available against the petitioners. Stop. Considering the above, this court is of the opinion that custodial interrogation of the petitioners may not be necessary for the ongoing investigation. Stop. Accordingly, it is provided that in the event of arrest of the petitioners named above in connection with the aforementioned shall be released on pre-arrest bail in connection with the aforementioned case, on furnishing bail bond of rupees 15,000 subject to the satisfaction of the arresting authority. Following conditions: number 1, appear 10 days. And the other 2 conditions, with the aforesaid observations, this AB stands disposed of.
Production cost is item 1.
Yes, Mr. Datta.
May it please, Your Lordship.
This is motion.
I have been implicated in this case on the basis of disclosure statement made by the prime accused, which is the Lordship is aware barred under section 25 of the Evidence Act. I will take Your Lordships to page 12, the FIR, my lord. The FIR is not against me, it is by the informant against the prime accused.
1 second, Mr. Datta. Earlier we have granted bail.
No, my lord, Your Lordship will find.
To one Anup Oja.
Anup Oja, yes. He is an absconder, my lord. Yes. Anup Oja. His bail was rejected. He came up for anticipatory.
Oh, we had this court had rejected.
Yes, rejected because he is a absconder and he is the prime accused, my lord, and there are so many things against
You are, sir, in fact, you see, you are similarly situated as that of Anup Oja, because while rejecting the bail of Anup Oja, your name also, this court has seen. Accordingly, another person, namely Sarifuddin Ahmed, has been arrested.
My lord,
You are for him.
I am for Sharifuddin, my lord.
Who has helped the accused person in registering the alleged for sale date.
My lord, that is the only allegation against me.
Attempt was made also to apprehend the petitioner, but he is evaded. So the allegations against you is that you helped the accused person in registering the alleged for sale date.
Registration. My lord,
How long you are inside?
My lord, it's 2 days, 14 days. Well, 14 days.
1-4.
1-4. And my lord, only thing, Your Lordship.
At present status, to CD is required, my lord.
Your Lordship can say one thing, if Your Lordship.
Mr. Datta, you are already inside.
My lord.
When can you have the CD, Mr. Parashar?
My lord, 3rd of April, my lord.
One consideration, if Your Lordship.
CD will be required. This court has already rejected.
My lord, I am concerned of that position. Your Lordship may say
Let
one
the
thing.
CD be called for list on
3rd of April.
3/4/2024. Sorry, Mr. Datta.
No, I am aware of that position, my lord. Only thing, his wife is a cancer patient and he was supposed to be
On
taken
3rd.
in the Chennai tomorrow, my lord. But then, since he is behind.
Sorry.
Your Lordship fixed on 3rd, my lord.
Ahil?
It's a very tough thing, my lord. I am aware of that.